everybody. Um, my name is Chris Hill. I am the president of the UTM chapter of the Honor Society of Phi Kappa Phi, and I'd like to welcome you all to our annual Muriel Tomlinson lecture, spring lecture. We have two lectures we do every year, one in the fall and one in the spring. The spring lecture, the Muriel Tomlinson lecture, is named after the original chair and founder of the UTM Department of Foreign Languages. And Dr. Muriel Tomlinson was very influential in the early years of our chapter, as well as a really important founding member, like founding faculty member of the actual Department of Modern Foreign Languages, which has now been folded in with English, and so is English in Modern Foreign Languages, but we still claim it, it's fine. I am here to kick off the lecture. Afterwards, there's a few cookies if you would like to avail yourself of one or two or three. They're paid for, so we should eat them. I would like to also mention, before I have Ann come up, Dr. Gathers come up and introduce our speaker for the evening. Some of you may have received an invitation in the mail or in email to join the Honor Society of Phi Kappa Phi. And if you have, congratulations, and I would encourage you to follow up on that. And it is a legitimate organization. We are for real, and we've got interesting things in store. So I would encourage you to avail yourself of that if you have received an invitation. Now, Dr. Gathers.
And thank you again for coming. Is this on?
It is on. It is on. Sounds good.
Thank you again for coming, and it's my honor to introduce my friend and colleague in a different department, but Dr. Patrick Baker. And I'll tell you a little bit about Dr. Baker. I had to write it down because there's actually a lot about Dr. Baker here, but Dr. Baker earned his Bachelor's of Arts in History and minored in Psychology. He received that from Virginia Military Institute. He has a Juris Doctorate, a law degree, if you don't know, from Appalachian School of Law in Grundy, Virginia. And he practiced in Abingdon, Virginia, at Penn, Stewart, and Eskridge, one of the oldest law firms in the state. He focused on employment, regulatory, and energy law before coming here as a faculty member in 2016. His research here has been shared at conferences, has been in publications, and media outlets including the Washington Post, ABC News, the Associated Press, and U.S. News and World Report. Hopefully you guys have heard of some of those. He's received numerous accolades while at UTM. I think almost all the ones you can get here, almost all the awards you can receive at UTM. The Ray and Wilma Smith Award for Scholarly and Teaching Excellence, James R. Cunningham Outstanding Teacher Scholar Award, the UT Alumni Association Outstanding Teacher Award, and he's going to talk to us tonight about the complexities and inconsistency of rules and regulations governing the ownership of underground mines. And I liked your title, A Presentation About Who Owns Nothing. So you can clarify.
Thank you. Good evening. I'm glad you all are here. Thank you so much. It's such a privilege to be here, and I really appreciate being invited to be here, so thank you all. So just a little bit here before we get started. You know, the question is who owns nothing? And so when I say that, everyone just kind of naturally like chuckles. It's funny to think about, well, you can't own nothing. It doesn't exist. But as this kind of unfolds, you'll appreciate the humor in that, but you'll also appreciate the complexity. I never thought that when I went to law school that I would end up being a mineral and energy lawyer, but that's where I landed, and then that's what I did. And then I never thought that I would spend as much time as I have wondering about who owns mine voids and pore space. All right, but one of the beautiful things about academia is we are afforded the luxury to go down those rabbit holes, so to speak, and explore. But my practice informed my teaching, and so this is rooted in an experience that I had in practice and a topic I had in practice, and I'm going to talk about it. But the first question is who owns nothing? And then we've already had one Seinfeld reference today. on the way over here. But this is my second sound field reference. Well, it should play when I hit the... You want me to click it? I can do that. All right, there it is.
Variety of ways, but the basic idea is I go ahead. I think I can sum up the show for you with one word. Nothing. Nothing? Nothing. What does that mean? The show is about nothing. What? No, it's about nothing. Well, maybe in philosophy, but even nothing is something.
Mr. Gallagher, your need is on the phone.
I'll call back. Gallrimpe.
All right. So it was supposed to go straight to the next slide. It did, and all the times I practiced it, I swear, that it could go next to the next slide. All right. That's okay. So is nothing really something? All right. And so when I first started with this topic, you know, the question is really who owns the absence of something? Who owns nothing? And so the root of this is what we call the mind void or the pore space. And what that is that refers to the empty space that's left underground after mining operations are completed. And essentially a large hole or cavity that remains once the valuable minerals have been extracted, and which may not be fully filled during the rehabilitation process. And so this void is the absence of, the mineral. So has anyone ever been in a coal mine? Has anybody ever been underground? All right, so John has, Dr. Hill has. Well, this is a mine void at night. Okay, if you go underground, this is what they look like. This is a mine void during the day. All right, so if you're down there. But I used to, go underground quite a bit with my clients. And so in 2009, I was approached by one of the attorneys for Consol to help out in this case. All right, and the case is Pocahontas Coal versus Consolidated Coal. And there were several lawyers working on the case, and the lawsuit was actually filed in 2005. And the root of the lawsuit is this, that when you mine coal, all right, obviously it's a giant hole in the ground, it's underground, but then coal is also porous. It's very light. If you've never held coal, it's very light. It's compressed plant matter. So I brought a piece of coal around. I'm going to pass that. If you haven't held it, it's surprisingly light. But coal, where it is porous, is very suitable to aquifers. And so when you mine, you have a large amount of water that you have to do something with. And you can't simply just discharge this water. The water's filled with all types of acid and minerals from the mining process. And so it's extremely toxic. So the question is, what do you do with this water? And it's very expensive to treat. It's very expensive to dispose of. And so in this case, Consolidated Coal came up with this idea when they were mining. We'll just pump the water into the abandoned mine next door. No one will know. Okay? All right? And so Consolidated Coal did that for 20 years. Okay? Now, this is not a small amount of water, folks. This is like 50,000 gallons an hour. All right? So over 20 years, you're talking about a large amount of water. So eventually, the owners of the Pocahontas assets learned that Consolidated Coal had done this, that they had discharged this mine water into their abandoned mine and flooded it. So, of course, at that point, even though it had been mined out, no one had any intentions of mining. The Pocahontas owners said, oh, but you can't do that. We were going to remine that. Okay? Technology's different. We can now remine it, and now we can't. Okay? You filled it up. And so in 2005, the lawsuit was filed, and this is the biggest case that I worked on in practice. The plaintiffs requested, I think, initially $350 million. And then my client, when I worked for Consol, we had conceded that we owed $20 million. All right. And so this went on for 5 years and led up to trial. And the trial was going to be in the summer of 2010. It was going to be about 8 weeks. And unfortunately, it settled on Memorial Day. On the night of Memorial Day, trial was going to start Tuesday morning with jury selection, and then it settled on Monday night. Why do I say unfortunately? Well, I was hired. At this point, I had already gone to work in academia, and I was a full-time professor. So who else has all summer off to assist with a case other than a professor? And so a main job of mine was as a jury consultant. All right, I had researched the jurors. I provided information on the jurors. And then I was going to be in the trial every day and take notes on the jurors, their reactions, and try to figure out which jurors were buying it, which jurors were not. Who were the jurors that were going to call the shots? Who was going to be in charge when they went to deliberate? And then every day I would then debrief counsel. So unfortunately it settled on that Monday night. Everyone was happy except me because I could have put one of my children through college with what I was going to make that summer. But it settled for $75 million. And in 2010, that was the second highest jury verdict in Virginia. Excuse me, the second highest judgment in Virginia that year. I think there was a products liability case over $100 million that year. So I became very interested in this concept of, who owns nothing, and why was there so much value or emphasis? Like, why did Pocahontas care? Okay, and so there's actually a lot of uses now for the pore space. It's actually a very valuable commodity. One of the big uses that we're going to see as time unfolds is to combat climate change. The number one producer or the number one facilitator of climate change is fossil fuels or fossil fuels. Where do fossil fuels come? They come from the earth. They're underground. That's where the carbon is. It's locked away. It's stored in coal. It's stored in oil. It's stored in gas. We have the ability now, scientifically, to pump the carbon back underground and to store it. All right. Now, it's still very expensive, and the argument against any new technology is, it's expensive, it'll never be feasible. That's what they said about the electric car. That's what they say about other technologies. Folks, it's always very expensive when it starts out, and then the cost comes down. But there are some carbon, there are some CO2 right here, and my picture is not the best, but it's pretty good. But there are some power plants that are using carbon capture technology and are pumping it underground and storing it. If we think about this space, there's not only the mine void, i.e. the space left after the mining, but we also have what we call pore space, which is typically associated with natural gas and oil and gas production. The gas is actually locked away in the rock. We then fracture it and we produce it. And then what we have underground is really a pore space. It's not a void, it's just fractures in the rock. How big is this pore space? This is the Balkan Shale in North Dakota. Okay? It's 1, 2, 3, 4, 5, 6, 7, 8, 8.5 Empire State Buildings. The Empire State Building is about 1,500 feet. The Balkan Shale is that, has that much room. And all that is being produced through fracking and production of natural gas. That carbon that then is produced could easily be pumped back underground and stored in that pore space. Now, why else is this pore space being used? Well, like in the Consol case, the Pocahontas case, it was simply being used to store wastewater. All right, natural gas companies now treat the natural gas. They then have to do something with it. Okay, they then pump it underground into pore space. They seal it and they store it. Then when there's a demand for the natural gas, they then can produce it. All right, so you can store natural gas, you can store carbon, you can store mine water. There's a myriad of ways. There's a value now. And so since there's a value, now everyone wants to own it. For the last 200 years, no one could care who owned it. All right? But now people want to own it. Obviously, if I have pore space or void space on my property, I would want to own it because I would want the mineral companies to have to pay me a lease every month. I would like to get a check for doing nothing. Isn't that a beautiful thing? So I'm going to talk a little bit about the case, the legal principles, and then I'm going to hit on the state laws, and then I'm going to talk about the Constitution, and we're going to look at this confluence of state law and federal law, or state law and Constitution. Now, in 1766, Professor Blackstone stated in his treatise on commentaries of the law of England that a landowner's title extends up to the heavens and downward to the center to the earth. It's called the heavens to hell principle. All right. I Googled the Latin phrase right here. I practiced several times to say it. Unfortunately, I could not do it. All right. So 2 and 3 word Latin phrases I'm very good at, like res ipsa loquitur. However, this phrase, after several minutes, I said, moving on. So American courts adopted this theory of ownership. So technically, on your property, you own all the way to the magma. And then you own all the way to the heavens, okay, to the moon. Now, what Blackstone didn't appreciate was technology. He didn't appreciate aircraft, any of these other things, because they didn't exist. So this legal principle has become somewhat unworkable or unmanageable. So technology changes the law. And so in 1946, in U.S. versus Cosby, the farmer brings a lawsuit against the military. They're flying planes too low, and it's disturbing his chickens. And the chickens are not laying well. So he brings a lawsuit and says that you, the federal government, have taken this property. And it's actually my property. And you're trespassing. And the U.S. Supreme Court said there's limits to this heaven to hell principle. All right, the aircraft, if you want to bring a nuisance action, bring a nuisance action for the diminution of the value of your property, but you don't own all the way to the heavens. And so this legal doctrine has been eroded. But now as far as all the way to the center of the earth, that's just as applicable today as it was yesterday. You do. And we're seeing that all the time as we now are fracking at 10,000 feet underground. And we're going to continue to go deeper as the technology improves. So the legal principles in this case, in the Consol case, which were so interesting to me and which are applicable now, is that property rights are a bundle of sticks. And I brought a bundle of sticks here. All right. And so if I get this bundle of sticks, we like to think about, well, we own this piece of property and it's ours. But I may lease out the oil and gas. I may lease out the crops to the farmer. I may sell the timber. And then what do I own? I own the surface. I'm the surface owner. Someone else owns the timber. Someone else is going to farm it for 10 years. Someone else has leased the oil and gas for the next 100 or 50. But I still have this stick in the bundle. I'm still the fee simple absolute owner. I'm the surface owner. So if you grant it, all right, it's called the free alienation of property. We encourage it to put property to the best use. But at some point, when that estate is extinguished, you cut the timber. There is no more timber. That stick comes back into the bundle. At the end of 10 years, I don't like how you're farming. I'm going to not renew the lease agreement with you. That stick comes back in the bundle. I may lease it or I may not lease it. But at the end of 50 years or 100 years, you have exhausted the oil and gas. You have mined the coal. It is no longer there. So it's not necessarily that the stick comes back in the bundle, but there is no more stick. It simply doesn't exist. What did you lease? You leased the oil and gas, or you purchased the coal. And so now it doesn't exist. That absence is the void. It's a complete juxtaposition. It's the opposite of the mineral. And as we're going to see here, in many states, the mineral owner winds up owning the void, which to me is repugnant. Because it's the absence of the mineral. I bought the coal. The coal is gone. The estate is extinguished. I now have to vacate the premises. So in this case, all right, so property law it's a state law function. So there's 50 different states, there's 50 different sets of property law. And every state is somewhat different. Now there are trends and there's similarities. But with the mineral grant and the reversion, everything that is granted is still owned. Everything that is not granted is still owned. And upon the extinguishment of these estates, those sticks then come back into the bundle. Now, what was interesting in the Consol case were the theories of recovery. The number one theory, there's two theories of recovery. One was trespass. You didn't have the right to store your mine water in our mine. What's the value of that? All right. My client said, well, it's worth $1 million a year. That's what we'll pay you. We should have paid you $1 million a year, and we didn't. So we're on the hook for $20 million. All right. Must be a good problem to just throw around millions, like $5 and $10. Yeah, we're on the hook. The most interesting theory of recovery in the case was quantum merit, also known as unjust enrichment. It's a contractual theory of recovery. Now you may think to yourself, well, wait a minute, Baker. Pocahontas didn't know. How could there be a contract? Sometimes the law imposes a contract where it would be fundamentally unfair not to impose a contract. This is called unjust enrichment. This is where, folks, the meat was on the bone. Trespass, no meat. Quantum merit, lots of meat. Here's how it works. This is the best picture that I could find. All right? So in a trespass theory, your neighbor backs his RV. It goes to NASCAR. He comes back from NASCAR. He backs his RV in. The back two tires rut up your yard. And you've had enough. He's done this now for 10 years. Every other weekend he goes, he backs the RV in. The back two tires right up your yard. You bring a lawsuit. You bring a lawsuit under two theories. One, trespass. One, quantum merit. Under the trespass theory, what are your damages? Some topsoil, some sod, $500, $1,000. So you can be successful, you can get it. But if you bring it under a quantum merit unjust enrichment theory, by allowing your neighbor to rut up your yard, you have saved him $100 a month storage fee for the RV. At $1,200 a year over 10 years, that's $12,000. Now, I didn't need an accounting degree from UTM to figure out that 12,000 is more than 1,000, okay? That was what Pocahontas effectively argued in this case. Pocahontas said, by you injecting our mine with this wastewater, we saved you $350 million. You would have had to treat it. You would have had to dispose of it. You would have had to build diffusion facilities. You would have had to get permits. There's this litany of things that you would have had to do with 50,000 gallons an hour. And by you just injecting it into our mine, we saved you all that money. So there were two theories of recovery, one of them being a property theory, trespass, the other being quantum merit, and then ultimately, like I said, it sold for $75 million. So when we interpret a mineral lease, and then right here, this is my coal law class, all right? I used to take them underground. The reason they're so excited is they go underground like once or twice a year, okay? If you had to go underground every day and work, you probably wouldn't be that excited, but they're very excited. So I used to take my classes underground. I used to go underground with my clients all the time. It's a very humbling feeling when you're 5 miles underground. You realize how insignificant you are. So this is a low boy, okay? It's made to go in about a 48-inch coal seam. You lay back on it, you drive in, and then you work on your hands and knees for about 12 hours, all right, or 8 to 10 hours or whatnot, and then you come out and you ride back out on the low boy. So when we interpret a contract, we interpret a mineral deed, we ask ourselves, or the court always asks themselves, what did the parties intend? So when we go back to 1850, 1860, 1870, these mineral deeds, these leases, these transfers, and we ask ourselves, well, who owns the void? The question is what did the parties intend? Well, the reality of it is probably neither party contemplated ownership of the poor sport. It was just a nuisance. Nobody really wanted it. And so when we look at these deeds and contracts, the question is, well, does the mineral owner own it? Does the surface owner own it? But the reality, when we ask, well, what did they intend? No one intended to own it. All right. So in these states follow what I call the American rule, the Pennsylvania rule, and these states have just found that the surface owner owns it, either by case law or by statute. These states have said, you surface owner, you own it, unless the deed or the lease says something different. Now, like if I was drafting the lease today, I would specify in there that my client, the oil and gas company, owned the void, realizing that there's a value to it later on and we may want to use it to inject or store. But this is the eastern coal fields right here. All right? So there's Pennsylvania, there's West Virginia, down here's Virginia, and then right here you can see this small little sliver of Virginia. Okay, these are the coal fields. There's only 7 or 8 coal-producing counties in Virginia, and right here they are. And right here in red, you see what's called the Pocahontas Seam. Pocahontas Seam was about 8 feet thick. All right, it made people wealthier beyond their wildest dreams. And so a lot of this has been mined out, but these are the coal fields. All right, and they run all the way from northern Pennsylvania all the way down to northern Alabama. In these states, Virginia being one of them, Illinois, Kansas, Ohio, Kentucky, in these states, courts or cases have found that the mineral owner owns the void. So pay particular attention here to Virginia. This is in response to the Pocahontas case. The Pocahontas case comes out in 2010. In 2012, the Virginia legislature passes a statute and says, you, the coal owner, you, the mineral owner, own the void unless there's something that states that you don't. Okay. We know how the wheels are greased politically, right? The lobbyists, et cetera, who has the most to gain from the mineral owner owning the void, the mineral companies. So the Virginia Code states, except as otherwise provided in the deed by which the owner of the mineral derives title, the owner of the mineral shall be presumed to be the owner of the shell, container, chamber, passage, space open underground for the removal of minerals, ... So in the aftermath of Consol, Virginia then passes this law, and then it doesn't sit well with me. Because once again, if we go back to the sticks in the bundle, you're essentially saying the mineral owner owns the absence of the mineral, but I only purchased the mineral. How can I own the absence of it? It's a complete opposite of what I purchased. So Virginia passes this statute, okay, and I think to myself, this is essentially a takings. This is a constitutional law issue. And so if we look at the Fifth Amendment, and there's a lot in the Fifth Amendment, mind you, okay? The framers were able to work in double jeopardy, indictments, and then at the end, and by the way, if we take your property, we have to pay you for it. I'm thinking between, like, the death penalty and everything else, taking our property is like the least, but at the end, hey, if we take your property, we'll compensate you. So this is the property clause of the Fifth Amendment, nor shall private property be taken for public use without just compensation. So Virginia passes this statute. I think to myself, this is a taking. All right, the Fifth Amendment is pretty clear. And so when we analyze a taking or eminent domain, and some of you may have been impacted by this, road projects, utility projects, railroad projects. When the government takes your property, the test is very simple. There's 4 elements. The government takes private property. It's been taken for public use and just compensation. And so I've highlighted public use because when we think about taking the void and giving it to the mineral owner, where is the public use? It's a private use. It's a private mineral company. Now, I floated this idea to a couple of people, and they said, no, it's not a takings. You're way off. And I said, I think it's a takings. And they said, you're crazy. I said, I don't think I'm crazy. So overlapping this state law is federal law. Okay? The Constitution, folks, is a floor. It's not a ceiling. The Constitution guarantees you a minimum amount of rights, and if the state wants to, the state can give you more rights. So good news, like in Tennessee, there's no federal constitutional right to hunt and fish, but in Tennessee, there's a constitutional right. This is the South, all right? We have a constitutional right to hunt and fish. Right. So in 2000, the city of New London brings a eminent domain action over a neighborhood. And that neighborhood was very depressed socioeconomically. The city of New London brings this condemnation action, and they said, we're going to take this property, and, oh no, we're not going to keep it and use it. We're actually going to give it to a developer. We've talked to the developer, and he's going to build homes, and it's going to increase tax revenue. It's going to generate more money for the city. So this is Suzette Kilo. All right, her family built that house in approximately 1893. She then challenges this as unconstitutional and says this violates the Fifth Amendment. You can't take this property and give it to a private company. It goes all the way to the Supreme Court, and in 2005, the Supreme Court issues Kelo versus the City of New London. Now, what's interesting about the case is that at the end of it, the Supreme Court says, yes, you can take private property and give it to private individuals. We've never said that public use means the government has to own it. You all are interpreting this too narrowly. Public use is very broad. And so this then sends shockwaves not only through the community but just through our country, because basically if the government decides they have something better for your property, they can just take it. We think there's something better than your farm, we're going to take it and give it to this developer. We think there's something better than your business, we're going to take it and give it. We're going to give it to somebody else. They're going to run a better business than you. We're going to take your business and give it to someone else. All right? So they actually did move Miss Kelo's house. All right? It's in downtown New London. And what's funny, when I boned up on this for the lecture, it still stands as a monument in honor of those families who fought for their rights and who inspired the nation. It's almost like Concord, Lexington, and then we go to the Pink House owned by Miss Kelo. Like it was this battle. It was like a tribute to all those fallen in the battle. So, but it actually is there, okay? But they did take the property. And folks, it actually has not panned out the way the City of New London thought it would. It hasn't resulted in this Shangri-La of increased revenue and tax. As a result of this, all right, in 2012, many states adopt anti-Kelo legislation. And remember what I said, the Constitution is a floor, not a ceiling. So the Supreme Court says, oh no, you've interpreted public use too narrowly. If the government can take the property and give it to someone else, that's fine. So the state of Virginia, state of Tennessee, a lot of other states pass anti-Kelo legislation. They actually pass constitutional amendments that state no. So in Virginia, the General Assembly shall pass no law whereby private property, the right to which is fundamental, should be damaged or taken except for public use. They then define public use, as a public service company, the government, the railroad, all those things are legitimate. But then in all other cases, a taking or damaging of private property is not for public use if the primary use is for private gain, private benefit, private enterprise. The same year they passed the statute giving the void to the mineral owner is the same year they passed the constitutional amendment that states that taking private property for private gain is unconstitutional. Once again, I said, I think this is a takings. And people say, I don't think so. I don't think it's not a takings. It may be some type of a regulatory takings, but I said, I'm pretty sure it's a takings. So here's our confluence of events. In 2000, the City of New London starts condemnation proceedings. SCOTUS then delivers their opinion in 2005. Pocahontas versus Consol is filed in 2005. The settlement's reached in 2010. This then results in anti-Kelo legislation be adopted in Virginia, and then Virginia also adopts the statute that gives the void and pore space to the mineral owner. So in 2015, I think to myself, this is clearly a takings. I know that I'm not crazy. Now, who owns nothing? So obviously there's a big hubbub here at this point about who owns this pore space and who owns this void. And so in 2022, we've got the big reveal, so stay tuned, all right? If we took a commercial break, this is when we would take it, and then we'd come back. We're not going to take a commercial break. But as you can see, this is not an episode of Suits, all right? Like we don't file the lawsuit, and then 45 minutes later, we get a judgment. This unfolds over about a quarter of a century, all right? So a little bit more like C-SPAN, okay? So in 2015, I start working on this article. In 2018, my colleague and I, Henry Webb, we published this Virginia Code section 55-1542, an unconstitutional taking of Virginia landowners' ownership and interest in mine voids, and then it's published in Oil, Gas, and Energy Quarterly. Basically, when we wrote the article, it is a brief. It is an appellate brief to challenge the law in Virginia. You literally could copy and paste it into your brief and then file it. All right, that's how we wrote it. We just wrote it for someone to use it, basically. Now, this is my oil and gas class. I used to take them on frac jobs, and then I would tell them before we went to the frac job, I'd say, whatever you do, don't get fracked. Okay, be real careful. But I would take them on oil and gas, and so right here, this is the side of a mountain. This pad has been cleared. This pad's probably maybe the size of a football field, maybe a little bit smaller than a football field. There's about 20 massive semis down there, and literally there's somebody that does nothing but helps the semis park. They're about 2 inches apart, and then once they start drilling, they drill for a matter of a day or two, and it doesn't stop. So if you've watched Landman, this is really how it unfolds. All the equipment descends. And then here we're fracking. So on this site by Range Resources, I think they were drilling at about 5,000 feet, and then they were going out about another 5,000 feet. And then the horizontal drilling, the GPS chip in the drill is so advanced that literally within 5 feet, a mile from the pad, you know where the drill head is. I mean, you really can tell the GPS. It's that sophisticated. And then what they do is they drill out in like a hub and spoke approach, right? So with one pad, they would drill, several wells, and then that well produces, it may produce for 30 or 40 years. Okay. So in 2018, I write the article. It's published. All right. Wait a minute, I'm missing a slide here. Well, maybe not. So in 2018, I'm not missing a slide. In 2018, this article is published. Now, what's interesting is in 2019, a group of plaintiffs in North Dakota file a lawsuit. The Northwestern Landowners Association filed a lawsuit against the state of North Dakota. North Dakota had done something very similar. North Dakota had created this statute that said you, the mineral owner, i.e. the pore space owner, you own the void, not the surface owner. North Dakota had also, almost simultaneously, passed an anti-Kelo amendment that states, we're not going to take private property and give it to private use. So 1 year after the article is published in 2019, this lawsuit is filed. And the Virginia Code is very similar. The Virginia statute is very similar. North Dakota is very similar. And in 2022, the Supreme Court of North Dakota finds it is a taking. It violates the Fifth Amendment. And they strike down the North Dakota statute, all right, as violating the North Dakota state constitution. This is taking private property and giving it to a private individual. So over that 5 or 6 years, when several people had told me, I don't think that's a taking, it was really nice to be validated in the sense that this was a legitimate legal argument, that it did hold constitutional muster, that it was worthy. Now, the only thing that I don't like is I wish the North Dakota Supreme Court had cited me, all right? That's the ultimate compliment that you can get as a law professor when a court cites your work or cites you as a secondary source. So not that I'm an expert, but courts all the time cite like Corbin on contracts or Prosser on torts. It would have been nice for the court to have said, Baker and Webb on voids, all right? So I just think it's too coincidental. Even though my article is not cited, the article is published in 2018, the lawsuit's filed in 2019. Folks, the oil and gas and energy field, it's a very small group. All right? It's a very niche practice. So if you were doing research on challenging this, my article is on LexisNexis. It's in Westlaw. It's going to pop up. You're going to read it. So unfortunately, we didn't get cited. Did that stop my colleague and I from writing another article declaring victory? Answer no. Okay, we did anyway. And so this is another oil and gas class that I had, and I would take them, like I said, about once a year I'd be able to take them on a drill site, and they'd be able to get hands-on. And then Proxen Law, whether it's oil and gas or coal, it was very important to be in the field occasionally to see what your clients were doing, to understand your client's business, so that when things did happen, you had a very good idea. So it's interesting when I watch Landman, and I watch the things unfold in Landman. Some of it I can relate to, some of it I can't. Typically you don't have a mine explosion and then the next week depositions. Usually it's mine explosion and then 2 years later depositions. So, like I said, it's not an episode of Suits. Now, what's funny here, so right here, Baker and Webb on voids, come into a town near you. Are we going to write a treatise on it? Probably not. We have written 3 articles on it. I've had about enough of voids, okay? I've learned more about voids than I ever wanted to. But here we are. Now, here's one thing that's funny here. You can see the young law students with me. This is me. I was a little younger and better looking then. But anyway, we're on the job, and then this is my colleague, Professor Harris. And this guy said right here, he tells the other foreman, he tells me, he said, in the oil and gas field, the people that work on the rigs are called roughnecks. All right? That's just a term of art. It's a term of affection. I remember him telling me, he said, we've got a problem. And the foreman said, well, what's the problem? He said, someone's going to get hurt today. And he said, why is someone get hurt? He said, because these roughnecks aren't used to these beautiful co-eds being on the job site. He said, they're going to be so distracted today, someone's going to get injured, which I thought was pretty funny. No one was injured, thank goodness. But we did enjoy, my classes always did enjoy that hands-on experience. All right, that's it. So that's all I've got. I appreciate you being here. And I can open up the floor to questions. Now, how many people knew about mine voids or thought about mine voids before today? Raise your hands. All right. The former president of the Mining Association. No one else. Here's the good news. You now have spent 45 minutes on mine voids. That's more than you'll spend the rest of your lives thinking about this. Okay? You've thought about it for 45 minutes. You'll wake up tomorrow. Your life will go on. You'll be perfectly happy without mine voids. And you probably won't think about it again. But I've written enough on it. I'm not saying I wouldn't write another article on it, but it would be nice. All right, it would be nice to be cited, but I do feel like we were validated that this constitutional argument that seems somewhat nuanced, that several people who I trusted had dismissed and said, "No, I just think you're wrong." But obviously the North Dakota Supreme Court didn't think we were wrong. So I'll just open it up to questions, and then I said 30 minutes. It's been 40 minutes. So that's pretty good. Miss Joyner. There's several people I have sent the article to, but more or less, Miss Joyner, actually before I wrote the article, I actually sent, when the Northwest Landowners case was published, I actually sent it to a couple people and said, see, I'm not crazy. All right. Dr. Shelton.
I'm curious about the farmer with the air right. Is it built again? But surely there's a limit. Is there a height that you own and a height you don't?
You know, and I don't know if there's a specific height. I don't think that there's a bright line like 100 feet or 200 feet. I think it's reasonable. And then what the court said is, look, if you don't like it, bring a nuisance action. And you'll be successful because your property is worth less. That's the proper remedy, but this is not a constitutional issue. I do think, as far as nuisance is concerned, we're going to see that more with airspace and drones. And then especially as drones become more popular, people are going to say, I'm tired of this drone being above my house all the time. But nuisance action was the proper action, not a takings. And so I think reasonable is probably the rule. Ms. Stowe. I knew I was going to get that question, and I have never emailed those lawyers and those practitioners to ask. All right? And maybe it's better that I don't know. If I email them and they say, we've never heard of you, all right, you know how fragile my ego is. So it's better to just kind of have that mystery that they read it and they said, man, this guy's really bright and we should use this idea. Like I said, it would have been nice if they would have cited it, but they didn't. But I'm okay with it. The main thing that I appreciate about it is that this constitutional law argument held water and that a Supreme Court of very smart people agreed that this was a constitutional violation. I think it's teed up for someone to bring the claim in Virginia. And I've emailed the article to several Virginia lawyers who I do plaintiffs' cases and who represent landowners. And I said, when you decide to take it up, here's your brief. And so hopefully that at some point in time that will happen. Because I do think the Virginia law is unconstitutional. You can't, I sold you the coal. I leased you the coal. The coal's gone. How could I have leased you the absence of that? I didn't sell. So at the bottom, that's all I can say about it. So is nothing really worth something? The answer is yes. All right, that nothing is worth a lot, especially if you're the surface owner and your minerals were severed 120 years ago. You haven't gotten a dime for them. All of a sudden now you can be paid. Okay, and so long-standing property law would state that you deserve to be paid, and I would say constitutional law says that you deserve to be paid. Any other questions? Webb, you tricked me there. You started to comb your hair. I thought it was a question, but you were just... All right. Well, thank you all. I appreciate it. Go ahead.
I looked up the Appalachian School of Law, and they have a natural
Resources Law Center.
law center. Do they have that one here?
I was the inaugural director.
Okay.
I was the inaugural director of the Natural Resources Law Center, and I taught oil and gas law and hard mineral law, along with some other classes. And so after practice, I worked there for a number of years, and then we all know how things like there's other opportunities and other things that you want to do. And so I had an opportunity to come here, and I've never looked back, and it's been very enjoyable. So, but I never thought I'd end up practicing mineral law or energy law, but that's my niche. And then, one of the nice things about coming here has been to do multidisciplinary research, and I've branched out off that and written several articles with colleagues on different business law and tax issues and things like that, things that I would not have done had I still been there, in that role. So it's been great. So I appreciate y'all inviting me. Go ahead, Dr. Hill.
I'm just curious, what kind of, obviously the kinds of like property law issues out here are going to be very different than out where I'm discussed. What kind of issues have come up in this region versus?
Well, what's interesting about it to me is that if you go to Gleason, it's the ball clay capital of the world. I mean, even like the sheriff's department, they've got the emblem. They're the ball clay capital of the world. But at the end of the day, what is that? Mining. And then the result of that is pit mining and Mine Safety and Health Administration and EPA and all those permits. And so, even though it's not coal mining, the reality is right here in Weakley County, there's 20 or 25 active mine sites right now that are producing clay. And they're going to produce clay for 20, 30, 40 years. And at the end of it, if you've leased the clay and they've exhausted the clay, what do you get back? You would then get back these, nice lakes on your property. Not a lot of topsoil, but you would get, So depending on if you leased the clay or you sold the clay, would depend on what stick you would get back in the bundle. So I know landowners have done both. They've leased the clay and then they've sold out, and the clay company is what we call the fee simple absolute owner. They own not only the minerals. I want to say a few years ago, my understanding is in between Sharon and Greenfield in the, I guess that's the middle fork of the Obion, they actually came out and tested for oil and gas and tested different areas for oil and gas. So could there be oil and gas development here at some point? It's possible, especially as the technology improves and you can drill to 15,000 feet, so. All right, well, I appreciate y'all coming very much. Thank you all.